I am pleased to bring before the House the Mental Health Legislation Amendment Bill 2024. This bill makes a number of amendments to the Mental Health and Cognitive Impairment Forensic Provisions Act 2020, the Forensic Act, and the Mental Health Act 2007 to improve oversight of forensic patients. Forensic patients include people who, while mentally unwell or cognitively impaired, have committed crimes, sometimes terrible crimes. They include people who are not considered criminally responsible for their acts because under law they either did not know the nature or quality of the act or did not know that the act was wrong. The fact that forensic patients are not considered criminally responsible under law for their behaviour does not lessen the significant trauma, anger and grief experienced by victims and their families. I am sure all members agree that it is important to recognise the pain and immense suffering of those who have been harmed and those who have suddenly and tragically lost loved ones. The pain and suffering experienced by victims and their families can be tragic and is lifelong. I express my deepest, heartfelt sympathies to all victims of crimes and their families who have been impacted by people in the forensic system. I have met a number of these families myself. I know that their grief is real, and I want the system to support them better. The forensic mental health system in New South Wales is a robust regime with responsibility for treating and managing patients with the aim of protecting the community. The forensic system is not about punishment. It is about ensuring that forensic patients are appropriately managed and provided with specialised care to minimise risk to the patient and others and ensure that patients are not released into the community or given leave unless and until it is safe to do so. The forensic system recognises these patients are unwell, that they require treatment, and that this must be done in a way that is dignified, but also recognises community safety and the deep grief of victims' families. The Forensic Act sets out the processes for the oversight and review of forensic patients. The Mental Health Review Tribunal is the independent semi-judicial body responsible for reviewing forensic patients and making decisions regarding their detention, care, treatment, leave and release. The tribunal must review each forensic patient every 6 months. At those reviews, the tribunal can make decisions relating to leave or release. However, the tribunal cannot make an order for release or leave unless, amongst other things, the tribunal is satisfied that the safety and of the patient and any members of the public will not be seriously endangered if the leave or release is granted. Recent events have highlighted concerns regarding the oversight of forensic patients, particularly in relation to their use of social media and the decision-making processes for granting leave. This is something the government has received direct representation on from families, from victim groups and from the member for Orange, Phil Donato, who has been a strong advocate on this issue. This bill directly addresses these concerns by introducing several key reforms. Currently, various conditions can be imposed when the patient grants leave or release to a forensic patient. There is a non-exhaustive list of conditions set out in Section 85 of the Act and that the tribunal can impose when granting release or leave. These amendments will explicitly empower the tribunal to impose conditions restricting or prohibiting forensic patients' access to social media or other forms of online communication where it is appropriate to do so. This reflects the evolving technological landscape and the potential risk that it can pose. By addressing this issue directly, we aim to safeguard our community and ensure the well-being of individuals. It is important that the tribunal has the power to consider, on a case-by-case basis, whether access to online communication is appropriate, and if so, whether the form of communication should be restricted or limited. While the tribunal can already impose such conditions, in today's digital world it is important that it is expressly recognised in the Forensic Act. As such, this bill amends the Forensic Act to make clear that the tribunal can impose conditions relating to prohibiting or restricting the use of social media or access to other online communications. The bill also makes changes in relation to the composition of the tribunal when granting leave. When reviewing forensic patients, the Forensic Act currently provides that the tribunal must be constituted by 3 members, including the President or Deputy President. However, when the tribunal is considering the release of a forensic patient, the Act requires that at least one of the tribunal, including the President or Deputy President, be the holder or former holder of a judicial office. This ensures that there is appropriate, robust judicial oversight before a forensic patient is released. The requirement to have a current or former judicial officer sitting on the tribunal currently only applies to release decisions. It does not apply to leave decisions. This bill changes this. Under the bill, the tribunal cannot make a decision relating to leave, other than escorted leave, unless at least one member of the tribunal, including the President or Deputy President, is the holder or former holder of a judicial office. This will bring leave decisions into line with release decisions. It will ensure there is appropriate judicial oversight of the decision-making processes for granting leave to forensic patients, which involves careful consideration of community safety concerns and the care and treatment of patients. I note that this requirement will not apply to escorted leave where the patient is escorted from the facility by a staff member. Escorted leave may be required when a patient needs to attend a medical appointment or access the external grounds of a mental health facility. Escorted leave requires a staff member to be with the patient at all times and is only accessed on a case-by-case basis with the approval of the treating team. Due to these new requirements that all leave decisions, other than escorted leave, need to be made by a tribunal that has at least one member who is a current or former holder of a judicial office, the bill also amends the Mental Health Act to make it easier for magistrates and judges to move between the court and the tribunal. Under the Mental Health Act, if a Supreme Court or District Court judge is appointed President of the tribunal, they retain their status, remuneration and entitlements. However, the current provisions do not extend to a magistrate appointed as President or to magistrates or judges appointed as full-time Deputy Presidents. This bill changes this. Under this bill, if a magistrate or judge is appointed President or full-time Deputy President, they will retain their judicial status and entitlements and the hire of the tribunal remuneration or judicial remuneration. This change will assist in attracting magistrates and judges to the tribunal, as it will allow for the transition of entitlements and enable judicial officers to easily return to the court. Further, it will allow for increased flexibility, allowing judges and magistrates to be appointed to the tribunal for short periods to deal with any unexpected increases in workload. The changes in this bill are important and sensible and will help address community concern and improve the judicial oversight of decisions relating to leave for forensic patients. In finishing, I would like to take a moment to once again acknowledge the victims of crime across New South Wales and their family. I want to thank and reiterate the important advocacy by the member for Orange, Mr Phil Donato, who has been a tireless advocate for victims of crime. The honourable member has worked closely with my office and the government on these issues and has demonstrated an unwavering commitment to supporting victims and advocating on this important issue. Personally, my conversations with the member for Orange have demonstrated his deep understanding of the challenges faced by victims and his commitment to putting their concerns at the forefront of reform. His advocacy has been significant in contributing to these amendments, and I personally am grateful for his contributions. Also, I'd like to pay tribute to the families of Emerald Wardell, who are here today. Emerald's grandmother, Shirley Wardell, and Emerald's aunt, Christy Smith. And of course, Advocacy Australia's Claire and Alice Collins, who have also been tireless advocates on these issues. These changes would not have been possible without your commitment to justice for Emerald and all victims of crime. So thank you. I am hopeful that this bill is a reflection of the New South Wales Government's commitment to improving oversight of these matters and to help in ensuring that our community feels safe, and I commend the bill to the House.